In this video, we will attempt to describe an accountant's liability to third parties under common law and related defenses. Now, the leading precedent-setting auditing case in third-party liability was Ultramar's Corporation versus Touche, which calls the Ultramar's Doctrine. Now, take a look for a moment to read the summary of the case, figure 5.4. As you can see in this case, the court held that although the accountants were negligent, they were not liable to the creditors because the creditors were not a primary beneficiary. In this context, a primary beneficiary is one about whom the auditor was informed before conducting the audit, a known third party. This case was established a precedent, commonly called the Ultramar's Doctrine, that ordinary negligence is insufficient for liability to third parties because of the lack of privity of contract between the third party and the auditor, unless the third party was a primary beneficiary. However, in a subsequent trial in the Ultramar's case, the court pointed out that there had been fraud or gross negligence on the part of the auditor. The auditor could be liable to third parties who are not primary beneficiaries. Now, the courts have since broadened the Ultramar's Doctrine to include third parties who are considered foreseen users, as indicated here. Now, foreseen users are members of a limited class of users that the auditor knows will rely on the financial statements. For example, a bank that has loans outstanding to a client at the balance sheet date may be a foreseen user. Under this concept, a foreseen user is treated the same as a known third party. Now, there are defenses that an auditor can use for a third party. Okay. And one of them is a lack of duty to perform service. The lack of duty defense in third party suits contends lack of privity of contract. The extent of which privity of contract is an appropriate defense and the nature of the defense depend heavily on the approach to foreseen users in the state and the judicial jurisdiction of the case. We also have non-negligent performance, as indicated before. If the auditor is unsuccessful in using the lack of duty defense to have a case dismissed, the preferred defense is this one, the non-negligent performance. If the auditor conducted the audit in accordance to auditing standards, that eliminates the need for the other defenses. Well, the thing is, the non-negligent performance can be difficult to demonstrate to a court, especially in jury trials when lay people with no accounting experience may make up the jury. So be mindful of that. We also have the absence of causal connection. It suits that often means non-reliance on the financial statements by the user. Assume that the auditor can demonstrate that a lender relied on an ongoing banking relationship with the customer, rather than the financial statements, in making a loan. In that situation, auditor negligence in the conduct of the audit is not relevant. Of course, it is difficult to prove non-reliance on the financial statements. The absence of causal connection can be difficult to establish because users may claim reliance on the financial statements even when investment or loan decisions were made without considering the company's financial condition.